Good morning, part 2. Happy Saturday. So this was filed on the 25th in Decastro versus Abrams et al. This is a supplement to plaintiff's motion for contempt and shortening of time. He says, since this motion was originally filed, additional contemptuous harassment has occurred. He doesn't specify what it is, when it was done, or why he is able to add new contempt to an already filed motion. And then he says, request for a closed hearing. Pursuant to Local Rule 7.1d, I hereby request an evidentiary hearing at the court's election on the issues presented in this motion. And the evidentiary hearing thing is something that's bugged me a lot. I don't know why he believes that he's entitled to an evidentiary hearing, but I also don't think he understands Rule 7.1. The first issue with Rule 7.1 is 7.1b, and a party filing a motion shall at the same time file a memorandum of reasons, that's your memorandum of points and authorities, citation of supporting authorities why the motion should be granted. Affidavits and other documents setting forth or evidencing facts on which the motion is based shall be filed with the motion. Additional papers. All other papers not filed as indicated in subsection B1 and 2, 2 is just the opposition to the motion, whether in the form of a reply brief or otherwise, may be submitted only with the leave of court. Now, he didn't get leave of court before he submitted this. And additionally, this is nonsense because he doesn't state what the additional contempt is. There's no specificity there. So, like, what is he talking about? He just wants the court to guess. This piece of paper is, well, this isn't even a piece of paper, but if this was a piece of paper, it wouldn't even be worth wiping your butt with. This is garbage. This is poop. And then this part. So first of all, he has a request for a closed hearing. Rule 7.1d requires that a request for oral argument. This is a request for an oral argument, not a request for a closed hearing. So I don't know if he's actually requesting closed hearing. A closed hearing just means that it's closed to the public and the press. Normally, you'll see those in criminal cases, like if there's some subject that's touchy that's going to prevent the accused from getting a fair trial or something like that, or like if there's like a child witness or something like that. You'll see them in juvenile cases. I do some work for a law firm that does immigration work, and I know that they have closed hearings from time to time in immigration. I don't know all the criteria for it because I don't really dabble in immigration law. It's not my bag, baby. But I don't know why he'd be requesting a closed hearing, or even if he is requesting a closed hearing, because he provides no rationale as to why there needs to be a closed hearing. What sort of sensitive information is going to be raised? So I don't know if he is, or if he took somebody else's work and just left that. I don't know, because then he's requesting an evidentiary hearing, and he's requesting it under 7.1d, which is a request for oral argument. So I just don't know. None of it makes sense. None of it makes sense. This is poop. This is garbage, and this is probably just going to irritate the court, to be perfectly frank with you. This is probably just going to irritate the court, because the court's going to be left in the same kind of position I am, trying to guess what he's requesting. And probably the court's going to find that he hasn't requested anything with sufficient specificity for the court to be able to grant what he's requesting. So that's what you got. Thanks for watching. Have a great day.